All right, we're going to go back on the record in 2023 CR 0042, Brittany Brown. And where we left off, Ms. Brown, you had told me some issues you were having. All right. I'm not a medical doctor, but before you go off of medication, it may be best for you to contact your doctor to see if that's something you should be doing. You understand?
Yes.
All right. So on this one, she was placed on probation in 2023. I'm not going to extend her. So probation, you all are recommending on Ms. Brown, you all are recommending SATF.
Judge, the recommendations for DDRF.
All right, DDRF. All right, and has she already been approved? There's no other.
Your Honor, I believe there was a similar issue with when she got off her medication to go to SATF, and then the SATF didn't accept her after that. And then I think, at least according to my client, there was an issue with DDRF not accepting her because she had gone off of her medication. So I think there was an issue on.
All right,
both sides.
so Ms. Brown, are you currently on your medications?
No, and I haven't been able to get back on them since SATA told me to get off of them so I can go to the program. And I got off of them and they just still denied me. And then I still haven't been able to get on meds. They haven't given them back to me. They have been off since April.
All right, so here's my question. The medication you've received, who was that through?
It was through here.
All right, so probation. Can we make sure that the jail knows that she's supposed to be on medication? So that,
So it looks like the eval is for MIC supervision only,
okay,
not for inpatient.
all right. So state. That was Mr. Dunn. My understanding is the state wanted to continue her.
Yes, they were asking to continue and extend for 2 years as well as DDRF, and we were asking. We weren't opposed to the continuation or to the extension, Your Honor. We were just asking for outpatient treatment, given the circumstances with the difficulty getting into DDRF and for SATF.
All right, and so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the CLO, at least the main one. She was aware of that issue. Both violations that are alleged are still for Ms. Brown. I think there was just a typo in the name.
All right, so you have no objection to the oral amendment to the correct name in the violation of condition 15? All right, so Ms. Brown, have you ever been out of custody since you've had this charge?
Well, yeah,
All right, so have you been out of custody while you've been on probation before?
yes, Your Honor.
All right, so,
I'm sorry.
no problem.
I've just been here since January.
All right, so you were placed on probation and then you were out of custody, is that correct?
Yes.
All right, and my understanding, we had DDRF was not available because of her length of probation.
Correct. She would need at least 1 year remaining for DDRF.
Okay. All right, so who were you living with?
My mom.
And has anyone talked to her mom to see if her mom wants her back in the home?
I have not been in contact with her mother, Your Honor.
All right. Do you have your mother's number?
Yes.
All right, so this is what we're going to do, because I don't want to set her up to fail. If you'll give her number to your counsel, then if you in probation can speak to her
Okay.
to see if she is okay with her going back to her home, then I'll be able to have an idea of what to do with this case.
Okay, can do that, Your Honor.
All right, thank you.
Thank you.
And probation, is drugs an issue in this case? I should say illegal substances.
I don't show any recent UAs, Judge.
Okay.
Probably because she had been in custody for these evaluations. The last UAs were failed to submit and a negative back in July of last year.
Okay, so what's going to end up happening, your attorney, you're going to give him your mother's number, and then the attorney in probation can speak with her. And if for some reason that's not an appropriate place for you to live, then we will figure out somewhere else for you to stay.
Thank you, Your Honor.
All right, thank you.
I'll make a call right now.
All right, thank you. Two CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state? Defense.
I'm here before Your Honor.
And are you Mr. Lewis?
Yes, Your Honor, I am.
All right, Mr. Lewis, did you review the document counsel, you're on this side.
Sorry, Judge.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Mark Daniel Lewis who was placed on community supervision in 2022 CR 8453 for the offense of unlawfully carrying a weapon with a felony conviction on January 13th, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State.
Violated condition number 4 in Bear County, Texas, the defendant Mark Daniel Lewis did then and there fail to report to the supervision officer as directed for the months of October and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Sure.
Your Honor, state waives all the violations.
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison?
Yes, Your Honor, I do.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor, I do.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, I think that the state's gonna make one recommendation and the defense is gonna request something else.
All right.
But the state is requesting state ISF followed by gang/ISP and then to hold GPS and SOMU in advance.
All right. And defense, what are you requesting?
Judge, couple of things. Mr. Lewis understands the seriousness of what he's facing, Judge. In the state ISF, my understanding is where he got into trouble before, correct?
Yes.
And so he was in lifetime recovery, Judge. That's what he's requesting the court to give him the opportunity to prove himself, get back on treatment with lifetime recovery. Judge, I also have a letter from a Mr. Juan Trejo attesting to Mark's character, Judge. I don't know if you want to see that or not.
Oh, sure.
Okay.
Thank you. So here's my question. I remember him. He's been before me previously. And previously it was a violation of 15G. He said that there were issues with ISF. I believe he said, I think either people were doing drugs or something else was going on in treatment. And, or either, no, someone was trying to fight someone, or they had Fight Club at the ISF. And I said, okay, we're going to check into that. And then what I ordered after he pled true to violation of 15G, I denied the motion, and it was the alternate mean conditions, and he was supposed to go to lifetime recovery. And people, it seems, are leaving lifetime recovery without telling me and leaving without my permission. So we need to start with 1, why did he leave lifetime recovery? And 2, why shouldn't I revoke him and send him to prison? So that's where I am.
If I can, I'll have to
Sure.
answer the first question.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mark Lewis.
All right.
Mr. Lewis, if you can tell the court why you left lifetime recovery the first time, sir.
I gotten placed on a zero tolerance contract with my counselor.
Mhm.
I was sent there by yourself, Your Honor, for a period of the 3-month program, and I was 2 weeks away from completion when placed on a zero contact order because somebody there had left a cell phone and they assumed it was mine and it wasn't, but that's beyond the point. I was on a zero tolerance order and then I gotten in trouble and somebody was cutting hair there and they were cutting my hair and they came and they said they're gonna write both of us up. And I took that to mean that they were going to they're going to violate the zero tolerance order. So I jumped to conclusions and I reacted wrong and I left. I have no other excuse besides that, no other reason. That's what happened and that's why that did happen. But I was doing the program and I was 2 weeks from completion when all that happened and everything just.
And what drugs have you been using since we have not seen you?
Honestly, I got back on IV usage of methamphetamine. I gotten really bad, like within 2 weeks of.
Oh, no, I can tell by your appearance.
Yes, ma'am. I gotten really bad within 2 weeks of there, and I really wanted to. I had found myself. I lost it again.
All right, so here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery. So those are his choices.
Judge, I would suggest that we go to safety first and give him the opportunity to go into treatment and get that done, Judge.
All right, anything else from either side? All right, violation of condition number 4 is true. I'm going to deny the motion, alter and amend conditions to include safety. And we can refer him to felony drug court. I don't think they're going to accept him with if there's a gang issue with him. He's to remain in custody until transferred to safety or felony drug court.
Your Honor, if he does not qualify for safety due to his sex offender registration, would the court consider state ISF again?
All right.
Judge, I'm checking on that with our coordinator for safety to find out if they'll take him, if it's just registration and not the current offense.
Okay. So we'll do safety or felony drug court. If for some reason neither of those places will take him, we'll bring him back here and I'll consider something else. And he's to remain in custody until transfer. And there is going to be GPS, partial, for treatment, any probation visits, and work only. If you come back here again, your fault, somebody else's fault, what's going to end up happening is they're going to file a motion to revoke, and you're looking up to 6 years in prison. And this tier thing, not going to work.
And Judge, I did confirm they will not accept him at safety due to his registration requirements.
All right, we'll see if felony drug court will take him. If they do not, then, well, so you all want to come back. If felony drug court does not accept him, then state ISF, that's cognitive and substance abuse.
I only do one track.
All right, substance abuse track then. All right, is there anything else?
Not for that, no. Thank you very much.
You're welcome.
Maybe it's you, John?
Yes. Hello. Afternoon. So the state has filed a motion to withdraw the motion to enter adjudication of guilt. So I'm going to show that it's withdrawn, and I'm going to make a notation that it was withdrawn with the noted violations here. All right. So I'm not taking any of this as true. It's been withdrawn, but I'm telling you that you had better get in line, because if you don't get in line, you know what could potentially happen? You could be getting in line at the prison. So if you don't want to end up potentially in prison, you better get in line. All right, is there anything you need help with from probation?
Probation has been pretty smooth.
All right, just talk with them to see if there's any reporting that they need from you. All right.
Thank you, Gerald.